The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Inovo Santon. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabar.net. The South African Bar Association, transforming the legal profession.
Good afternoon, colleagues.
Good afternoon, Bert.
Right, if we can start then. Firstly, Ali, thank you so much for doing part 2 of this presentation. The first part, for those of you who may have missed it, is still available, and you can have a look at it at the South African Bar Association website. It was extremely informative, and I'm looking forward, so do we all, to another informative session. For those who may have missed it, a brief introduction about our speaker. Mr. Ncume is a managing director of Ncume Labour Consulting. He's an admitted attorney. He completed his LLB at Nelson Mandela University, served his articles at Gravensteins Incorporated in Port Elizabeth, where he gained what can be considered as invaluable experience in civil litigation and developed a consuming passion for all facets of employment law. Whilst pursuing his master's degree in labor law, Mr. Ncume involved himself in all aspects of labor litigation, consultation and training. This was undertaken under the auspices of Gravensteins, as well as the Nelson Mandela University Labor and Social Security Law Unit, who recognized his determination and superlative potential. When I had the benefit of attending the previous presentation, I quite enjoyed Mr. Ncume's energy. At some point, I felt as if I was attending a church service, and I'm sure Mr. Ncume may have heard this compliment that there's a pastoral manner in which he addresses his audience, which is quite invigorating. So, Mr. Ncume, without further ado, I'm going to hand over to you, and you can take us through your presentation. I'll ask my team to share the screen with you.
Okay, thank you, Advocate Ford, for the introduction. And I trust that the audio is fine, and I hope that there is no issue with connections. Whilst I am preparing the presentation from my side, I just need assistance for someone to make me the host so that I can be able to share my screen. Just as much as Advocate Ford introduced me, for those who have never met before, my name is Ali. My surname is Ncume, obviously. I am based in PE. I'm a labor law attorney. And what I normally do, I facilitate trainings on all aspects of employment law, and I advise and I'm involved in consultation, legal opinions, and drafting of all documents which manage the employment relationship. So I was invited to come to this platform to do a presentation on chairing disciplinary hearings, and this is part 2 of that presentation. But for those who are joining for the first time, you know, the reason we couldn't finish the first part, the presentation last week on the last time, is because there was time issues. You know, I tend to go on, and I'm not concerned about time. So I don't want to spend a lot of time recapping on what we covered in the past, but I am just going to touch base briefly on what we touched base on the previous session, so that whoever is joining for the first time at least has an understanding on how we got where we are. Advocate Ford, insofar as being a pastor is concerned, insofar as being a pastor or having pastor style which looks like a pastor style, I'm not sure. You know, every time I do this session, my neighbor is always complaining that I'm making so much noise, but this is how I engage, unfortunately. Thank you so much for the compliment. I take it as a compliment. So for those who are joining for the first time, the discussion last week, or 2 weeks ago rather, was based on chairing disciplinary hearings. Obviously, we understood from the outset that this discussion falls within the ambit of labor law. We can't be talking about chairing hearings if we are not talking about the legal framework which falls under employment law. And the emphasis we drew last week is that we must always be mindful of the fact that in practice generally, every time someone refers to labor law, you will take note that they call labor law employment relations, or they call it industrial relations, or employee relations, or people's officer, etc. And all these terms, you will understand that they indicate some form of a relationship. Industrial relations, we are talking about the relationship. Employee relations, we are talking about relationship. People's officer, we are talking about interacting with people. So in all employment law processes, we must never lose mind or lose sight of the fact that we are dealing with maintaining a relationship. Labor law is the only field in law which is about maintaining relationships. So whenever we are involved in chairing disciplinary hearing, we must understand, although this process seems like a formal process, it forms part of processes which fall within the ambit of managing employee relations. So chairing a hearing is not about executing a mandate. It's not about going to the hearing so we can get paid, so that we can make a finding which favors the employer. We are there and we are involved in processes of maintaining the relationship between the employer or the employee. Because as chairpersons, we have no idea of what the outcome is going to be. So it's pointless being involved in a hearing, and then when you leave the hearing as the chairperson, the relationship between the employee and the employer is sour, because when you were chairing the hearing, you were not concerned about the relationship. So once we understood 2 weeks ago that concept, but this process forms part of managing employee relationships, it changes your mindset as a chairperson. As a chairperson, you are involved to try and deal with the issue and try and maintain the relationship. And then the second thing we focused on in the previous sitting is that we always have to understand as chairpersons that most employees in the labor market are vulnerable employees. And sometimes they don't understand these processes. Whenever they hear the word hearing, I mean, when I grew up, if someone says there's a hearing, in my mind, someone is going to jail, okay, hey, it's something hectic. The mere fact that process is called a hearing is already intimidating to an employee. The mere fact that the employee prior to that step receives documents, notice to attend hearings, bundle of documents, the suspensions involved, it's intimidating. So the manner we conduct hearings, it must be in such a way that we understand, but we are dealing with someone who is vulnerable. I'm talking in the employee's context. Obviously, in the employer's context, the people are more skilled. HR department is skilled, the ER team is skilled, so they understand the processes. When they are arriving in the process, they are relaxed. They've got no stress, unlike an employee when we are comparing the ability between the two. So we understand we're maintaining the relationship. We understand we are dealing, one of the parties is the vulnerable employee. The next thing we discussed is that we need to be aware of the steps we follow within a disciplinary hearing. What steps do you need to follow? Because in practice, what normally happens, I mean, I'm not saying every practitioner does it, but all people who chair hearings have to submit an invoice. You know, the quicker you finish the hearing, the quicker you can submit your invoice. People have lost the plot and they fail to understand the reason behind a disciplinary hearing. And the reason behind a disciplinary hearing is a concept which has been endorsed previously in our employment law. You know, we're talking about in the Latin periods where it's always been endorsed that an employee should always be given a chance to state a case in response. That's why we are in a hearing. We are not there to rush the hearing. We are not there for the purposes of doing our services and filing an invoice so we get paid. We must understand and endorse the whole process in such a way that we deal with the issue and we maintain. To do that, you must understand the steps of a disciplinary hearing. Now, unfortunately for us as legal practitioners, there is nothing in law which dictates how a disciplinary hearing should be held. You can look in the Labor Relations Act, you can look in any provision or in any statute. There is no statute which says the chairperson must do A, B, C, D, E. So based on practice, there has been some form of steps which have become common in most workplaces, in most institutions, or in most legislative forums, which people have gathered and realized, but these steps seem to be common, so let's start applying them. The CCMA has its own steps. Bargaining Council follow the CCMA steps. If you look at internal disciplinary hearings, we kind of mirror the same steps in the CCMA or Bargaining Council, but there is no structured or legal obligation or a statute which dictates the process which needs to be followed. So the steps we discussed or we started off discussing last week are common steps which you will normally find in practice. Now, there were preliminary things. I'm nearly finished with the recap. Preliminary things we discuss outside the steps which are also important for chairpersons. Remember, as a chairperson, the mere fact that you are appointed by the employer, you're going to be paid by the employer, you are coming to the employer's premises if you are external. Even if you are internal, you are appointed by the employer, you are paid by the employer, you work for the employer. Before you even arrive in the hearing, there is already a perception from the employee's perspective that you're going to be biased. You are attending a hearing for the person who's going to pay you. There was a phone call which was made, which appointed you. So this employee already has the perception you're going to be biased. So as a chairperson, you can't be adding already on the perception which the employee has prior to the disciplinary hearing even commencing. So we discuss issues such as arriving at the venue first as a chairperson, and then you're sitting with an initiator before the hearing starts. The employee arrives in the hearing. What are you and the initiator talking about before I arrive? When there's a coffee break, you go and have coffee with the initiator. How can you be discussing or having coffee with someone who is arguing against me as an employee? When you are greeting us in the hearing, you shake the initiator's hand first. Hello, Paul. How are you? Long time no see. When you are shaking the employee, hello, Keisha, full stop. You're creating the perception of being biased. The mere fact that you are sitting closer to the initiator in the hearing and the employee is sitting across the room, you are creating the perception of being biased. So we have to make sure even before we start the hearing, we don't dig the hole of being bias or that perception deeper, because that perception already exists before you even conduct the hearing. We come to the hearing. If the initiator arrives to the venue before the employee, we tell the initiator to wait outside, because we don't want to be caught up sitting with the initiator. If the initiator is saying, Paul, come, let's go have coffee in the kitchen, you say to the initiator, no, I'm fine. You can bring my coffee here, I will have it here. You can sit outside. If there's a break or an adjournment during the hearing, you can't be sitting with an initiator. Perception of being biased. If the hearing maybe, there was a situation where I arrived at an incorrect venue for the hearing, The employer came to pick me up to take me to the correct venue. Just imagine that thing. I'm in a car with an employer. I'm the chairperson. We're going to the correct venue. Those perceptions of being biased are escalated or aggravated before we even start the hearing. So at hurdle number one, we must make sure for a world-class chairperson that we don't involve ourselves in situations where we aggravate or amplify the already existing perception of being biased. Now, let's say we've dealt with those issues and now you arrive in the disciplinary hearing. The primary question which we focused on in the previous week is, how do you conduct that hearing? And I think that's where we ended off last week. We were talking about the steps of the disciplinary hearing. And I mean, I don't expect everyone to follow the steps I dictate. You know, I mean, we all have a particular way of dealing with issues or handling hearings. You know, you have your own style, I have my own style. This is my own style, which I normally train on, and I kind of feel as if it works for me. I'm talking in the context of being a CCMA commissioner as well. I'm also a CCMA commissioner, so I kind of have an idea of how procedural fairness test is passed at the CCMA, and I utilize that knowledge or that skill or that experience of me being a CCMA commissioner in formulating these steps, and these steps have never given me any problem. Step number one, presence. I discussed this last week, but now I am just ironing it out. Just imagine chairing a hearing and you are not sure who the parties are before you. Just imagine chairing a disciplinary hearing and one of the parties is a service provider. Just imagine chairing a disciplinary hearing and one of the parties is a subcontractor. We have to always make sure as chairpersons that we understand we can never be in a hearing without an existing employee or employer. Only employees can be disciplined. I emphasized this in the last sitting. I've been involved in hearings where I sit and I look at the left-hand side and I ask the guy, hey, do you work for the company? And the guy says to me, hi, I just come here to fix computers 1 day a week, but now something happened. Now they want to fire me. I'm an independent contractor. How can an independent contractor be disciplined? Only employees can be disciplined. Only employees can receive warnings, suspensions. Only employees can be retrenched. Only employees can be taken to incapacity proceedings. Only employees have remedies in addition to employers at the CCMA. Everything is about employees. Never underestimate the confirmation of presence. Are you an employee? Remember, insofar as presence is concerned, we have the employee. We might have the employee representative, which might be a shop steward or a fellow colleague. In some instances, an attorney, should the application be made. There is this principle a lot of employers always rely upon, that attorneys are not allowed to attend disciplinary hearing because of policies. A company's internal policy, such as a disciplinary policy, cannot trump an employee's right to a fair hearing. We can't contract out of fairness. There are employees in workplaces based on their religion or culture who cannot associate themselves with unions. You know, I've got a Muslim friend. I always ask him, what party do you support, ANC or DA? He says, I don't support any parties because of my religion. I can't be supporting any parties. What union? I can't join unions. And now we have these policies which says you can either be represented by a union or a fellow colleague. Just imagine my religion does not allow me to join unions. Just imagine I've got a freedom of association. I don't want to be part of a union. And when I approach fellow colleagues and I ask them to represent me, they say they don't want to get involved. I can't ask a fellow employee. I can't join a union, which basically means the policy now, in terms of the policy, I have to run my case alone. Never underestimate exceptional circumstances. Attorneys can represent employees should an application be made. So presence, we've got the employee, we've got a fellow colleague or a shop steward or an attorney should an application be made to the chairperson. On the other side, we've got HR and we've got the initiator. We confirm. And then within this step, it's quite important as a chairperson, I emphasized this last week, to identify whether or not is there any objection to you being a chairperson. I had a hearing last week in Cape Town, last week Wednesday. And during the hearing, I said to the employee, but hey, Fandin, You see me every week, I come here to advise. You know I've got a relationship with this employer because I'm an attorney of this employer. But now I've been invited to chair your hearing. I just want to let you know that even though I have a relationship with this employer, I am here to be impartial. I am here to listen to your evidence. Is there any objection you have against me being the chairperson? He said, no. I heard it on record. When the matter is referred to the CCMA, he says, the chairperson on the referral form is biased, he has a relationship. But I already confirmed or asked him, does he have an objection? So sometimes as chairperson, you predetermine issues you might face in the future. Obviously, an employee might challenge procedural fairness. Obviously, if you have a relationship with the employer, the employee might challenge or raise the issue of biasness. So it's quite important during the introduction, you ask, hey, Fandine, do you have any objection to me being the chairperson? So presence, any objections, etc. Step number 2, we're dealing with the charges. Don't be that chairperson who knows the charges before the hearing. How can? A chairperson is supposed to arrive at the matter or within the disciplinary hearing without knowing the facts of the case. The moment you know the facts, it affects your mind because you are thinking in your flight, oh, this employee did this. You might decide the case on your way there. That's why in a disciplinary hearing and even in the CCMA, we have a stage which is called opening statement stage. That stage is to give the chairperson for the first time a brief introduction to the facts. There would not be a need to have opening statements if the chairperson knew the facts before the hearing. So the reason in disciplinary hearings or at the CCMA, the commissioner or a bargaining council normally says, do you have any opening statements? It's because he wants to understand the facts before he starts the evidence stage, because he has no knowledge of the facts. Sometimes employers involve people to draft charges and they say, come chair the hearing. You drafted the charges. How can you investigate and then be the chairperson? You will never rule against your own investigation. So we must avoid putting ourselves in situations where we amplify that perception of being biased. We put the charges to the employee, step number 2. Remember now, if the employee pleads guilty, now we have to start the evidence stage. If the employee pleads guilty, there's no need for us to enter the evidence stage, because remember, the purpose of the evidence stage is to establish guilt. But if an employee pleads guilty, then there's no need for us to hear evidence. But remember, chairpersons, we don't know the circumstances which resulted to an employee pleading guilty. That's why I said last week that if an employee pleads guilty in your hearing, don't be that chairperson who is running for the finish line and you say, okay, fine, if you plead guilty, it means I find you guilty also. Let's look at mitigating and aggravating. How about confirming whether or not the employee is pleading guilty voluntarily? Except for him, you are pleading guilty here. Do you understand the consequences of pleading guilty? Do you understand if you plead guilty, it means me as the chairperson, I don't need to give the employer a chance to establish guilt. Are you pleading guilty voluntarily? Did anyone coerce you to plead guilty? Or is this something? There was a case I was involved in a municipality where the initiator met with the employee before the hearing, and the initiator said to the employee, if you plead guilty, I'm going to give you a warning. When I asked the employee how you plead, he says guilty, and he was expecting a warning. At the end, I recommended dismissal. He says, now, I didn't want to plead guilty me. The reason I pleaded guilty is because the initiator said, if I plead guilty, I'm going to receive a warning. So it's very important we satisfy ourselves to the plea of guilty. Make sure the employee is pleading guilty voluntarily without any coercion. If the employee pleads guilty, it's very important you explain the process to the employee. I mean, the previous hearing I had, I think I explained this example in the previous sitting. There was an older generation lady who was in my hearing. She was sitting like this. All she said, yes, chairperson. Hi, chairperson. Hi, Put. Hi, chairperson. Mama, do you have any evidence? Chairperson, I'm fine, me. Mama, do you understand? Right. She never understood the process. So sometimes we have to play an active role in a hearing. You know, remember, in a hearing, you can play an adversarial role where you just let the parties talk themselves and you are just listening. Or sometimes you can play an inquisitorial role, meaning you involve yourself, you assist parties where you see there's a lack or there is a lay person who you are dealing with. So we have to make sure parties understand the process. Have you ever been in a disciplinary hearing before? Do you understand that you can have witnesses? Do you understand that you can have a fellow employee representing you? Do you understand that you can have an interpreter? Do you know what is going to be happening today? Do you have any documents you're going to be submitting? Do you know you could bring documents? Do you make sure the person understands the process? You are not there to represent the employer. You are not there to represent the employee. You are in between. You are impartial. The only trap you're going to fall in as chairperson is when you adopt the mindset of executing mandates. I work for Ncume Labor Consulting. If I'm a chairperson at Ncume Labor Consulting, I can't rule against Ncume Labor Consulting. No ways. My director is going to be angry. You want to, you must never be a chairperson if you want to execute mandates. Being a chairperson, you must be comfortable in ruling against your client. Being a chairperson, you must be comfortable in ruling against your HR director. You are not there to favor anyone. So we need to make sure the parties understand the process, you know, and they understand their rights, etc. Once you are satisfied that the person understands the process, and you are satisfied that the person understands their rights, then you can start entering the stage of evidence. One thing I want to emphasize about evidence stage, the evidence stage is the most stressful stage for the parties to a hearing. Because there is this perception in a disciplinary hearing that the person with the most bundle of documents is prepared. You know, and a lot of employers, they come with 100 pages, 200 pages, 900 pages, 900 pages, whatever pages. And a lot of chairpersons are so misled by these documents that they rule in favor of employers or whoever has the most bundle. We must understand the rules which apply in the evidence stage, chairpersons. The first most important rule for chairpersons is that we must never forget who bears the onus of proof. We must never forget, at one stage I was in a hearing and the hearing started and we entered the evidence stage. I think I was marking, you know, I facilitate under NMMU the CCMA training for future commissioners. So we get to a stage where we give commissioners their first cases, then we watch them to mark them. I was watching a case of a prospective commissioner and we entered the evidence stage and then he said, employee, you can start your case. But in my mind is that we are in a disciplinary hearing. Yeah. The person who bears the onus here is that the employee committed the misconduct is the employer, which means when we starting the evidence stage, the person who bears the onus to establish guilt is the one who is supposed to lead the evidence first. If you understand the party who bears the onus, it gives you an idea on how to run your process, because we always ask ourselves when you are doing opening statement, who must talk first? Is it the employer or the employee? When you are doing this stage, closing arguments, who must talk first? Is it the employer or the employee? When you are doing, people don't understand who must talk first. Remember, we are guided by law in these principles. The evidence stage, the person who bears the onus is the one who must start the proceedings. And if we are in a disciplinary hearing, the person who bears the onus is the employer. I don't want to get too legal. I mean, there's so much case law to this effect. We have various cases. We have the Asamang case, which says the person who bears the onus must start labor court judgment. We have the Samu case, I think on behalf of Fulungile, also labor court, which says the person who bears the onus must start. We have Umabota case against Utokiso, dispute settlement, which also says the person who bears the onus must start. So those principles are guiding to the chairperson. Employer, we are in the evidence stage now. according to our legal framework, you bear the onus to establish guilt. So which means in this evidence stage, you are the one who's going to be leading evidence first because you bear the onus. Who bears the onus is the employer. And also it's very important whilst you are starting the evidence stage, chairpersons, that you remind the parties of the standard of proof which is applicable in the hearing. I had a case now recently where an employee was seen in a camera walking past to a stockroom. He went to a corner and he drank a bottle of alcohol in that corner. That camera, unfortunately, doesn't see that corner. So we only see him going towards the corner. We don't see what he does in that corner. He walks out. The security guard went to the same corner and he found a half-drank bottle of alcohol. But the security guard was smart. He did not remove that bottle there. He left it there. That employee again went straight to that corner. We don't know what he's doing when he left. The bottle is empty now. So no one saw him drinking the alcohol. In the disciplinary hearing, his focus was, show me evidence which shows me that I drank. Where is the footage showing me that I drank? Where? So he was thinking that the standard of proof in a disciplinary hearing is one of beyond reasonable doubt. So a lot of employees, they attend the hearing thinking, but they will never prove it. You know, they can't prove 100% because they don't understand the standard of proof. You know, they need evidence to disprove beyond reasonable doubt, whereas the standard of proof is different. So it's quite important that we don't put the parties under the bus. Since we are starting the evidence stage, I just want to highlight the standard of proof. The standard of proof in this hearing is one of balance of probabilities. I am not here as the chairperson to prove 100% whether the employee committed this or not. I am here to listen to the evidence to see which version is likely. A chairperson, the word balance of probabilities is difficult for an employee. I mean, come on. You can say to me as an employee, the evidence star proof is balance of I don't even know what you're talking about. Balance of probability. These terms are difficult. So we need to dissect these terms. I understand some of us are in the legal sphere, but we need to dissect this term. Mama, balance of probabilities mean I must just see me whose version is likely to be true. I am here for likelihood, not to prove 100% whether or not you've committed this. I mean, there's so much case law to this effect as well. I mean, most of you, I'm sure you read case law. I mean, advocates are here, HR people are here. We've got government cases. We've got what other cases are popular? Cooper case. We've got combined services cases. Supreme Court of Appeal Cooper case, which also endorses this principle of balance of probabilities. Now, the parties understand who bears the onus. The parties understand the standard of proof. Now you say, okay, fine. Now since you understand, now we're going to start the evidence stage. Unfortunately for parties, the evidence stage in a disciplinary hearing, the terms people use to refer to the stages, they are complex. Examination in chief, cross-examination, re-examination. Yeah, difficult terms. But we need to explain this to the participants. There are 3 stages within at the evidence stage. We have examination in chief, when evidence is being led for the first time. We have cross-examination, when the other party is disputing the evidence. We have re-examination, when the other party clarifies whatever transpired during cross-examination. We need to be able to explain these things to the participant. Now, insofar as you are concerned as chairpersons, we must understand the rules applicable in these stages. A lot of employers, they like to lead. They like to ask rather leading questions during the evidence stage, examination in chief, leading questions. And chairpersons are sitting there listening to the leading questions. What is the purpose of having a witness in a hearing? To see the credibility of a witness and to try and see if the witness can recall the facts. So if an employer is leading questions, then it defeats the purpose of examination in chief. Practical example, was it 9 o'clock that you saw Ali there? Obviously the witness is going to say, yeah, it was 9 o'clock. Was Ali wearing a red t-shirt? Obviously, the witness is going to say, yeah, he was wearing a red t-shirt. Did Ali go upstairs? Obviously, the witness is going to say, yeah, Ali went upstairs. These questions have answers within the question. In examination in chief, employers or employees should ask open-ended questions. What time did you see Ali? Not, was it 9 o'clock? What color was Ali's t-shirt? Not, was he wearing a red t-shirt? Where did Ali go afterwards? Not, did Ali go to second floor afterwards? So we must be careful with those questions because they assist the witness. And the witness is supposed to be credible. Cross-examination. Always remind the other party of the consequences of not conducting cross-examination. Us as chairpersons, if the other party does not dispute the evidence of the other party, we have no choice but to accept that evidence. In my hearing on Tuesday, on Wednesday in Cape Town, the employer spoke for 10 minutes. And I asked the employee, do you have any questions for the employer cross-examination? Then the employee says, no, not at this point. I'm like, ow. Then I say to him, do you know about if you don't ask any questions, it's cross-examination this? That means that version is not disputed. I must accept it as true. I don't have any questions, Menyel. Because, and I'm sitting there, I'm thinking, hey, this employee doesn't know what he's doing. I say to him, again, Godman, I'm repeating this thing. Do you know if you don't ask questions or put your version, I have no choice but to accept that version because employees don't understand. So we need to put employees or expand their awareness and make sure they understand the purpose of cross-examination. Re-examination. Re-examination is not the stage where people introduce new evidence. A lot of people, they lead evidence, then cross-examination kicks in, and then they want to introduce new evidence on re-examination. Re-examination is when we clarify things which transpired during cross-examination. Practical example, let's say in examination in chief, the employee says, I saw Ali at 9. And then on cross-examination, the same employee says, I saw Ali at 10, meaning now he has changed his version. Now on re-examination, to clarify, the other party might say, yeah, Fandine, on examination in chief, you said 9 o'clock. On cross-examination, you said 10 o'clock. Now I'm trying to clarify, we're on re-examination. What time did you see Ali? 9 o'clock. So re-examination is clarifying issues, not about introducing new evidence. And also, chairperson, in the evidence stage, never admit inadmissible evidence. Yeah, but a lot of people underestimate this statement. We are only supposed to make our decisions on admissible evidence. And I don't want to get into details on what constitutes admissible evidence because otherwise I will talk until 7 o'clock. Admissible evidence, you should know in your mind right now, but in a hearing, there is different evidence. Other employees are going to bring statements. Other employees or employers are going to bring video recordings. Other employers are going to bring breathalyzer tests. Other employers are going to bring polygraph test results. Other employers are going to bring witnesses. Others are going to rely on audio recordings. Remember, there are rules of evidence which dictate when such evidence is admissible. We only make decisions on admissible evidence, and in order for evidence to be admissible, it must be real and reliable. You know, and I kind of feel as if, you know, I don't want to open that door, but at this stage, we must just accept that we can't make decisions based on inadmissible evidence. For example, statements are inadmissible, generally. Just imagine an employer bringing 10 affidavits in a hearing to prove guilt, and then you accept them as chairperson and you say to the employee, hi, these 10 statements say you did this thing, so I believe these 10 statements. What about the employee's right to cross-examine the witnesses? How are we going to ask questions to documents? Doesn't a document deprive an employee of the opportunity to cross-examine the witness? So the statement, in order for it to be admissible, the author must be present in the hearing so that they can testify to their statement. In the event there has to be cross-examination, we ask the author, how does the chairperson determine the credibility of a witness via a document? You don't see the demeanor of the witness, you don't see the facial expressions, you don't see anything because there's a document. So there is evidence which is admissible and there is evidence which is inadmissible. So in the evidence stage, we always make sure we rely on admissible evidence. So the evidence stage kicks in And obviously, the employee's evidence stage also kicks in. We give the employee a chance for the employee to embark on examination in chief. We give the employer a chance to cross-examine. Obviously, we give the employee a chance to re-examine as well. Because these stages are vice versa. The rules of admissibility of evidence apply when the employee is leading his case as well. You know, I kind of feel as if you must spend time and invest in reading in the admissibility of evidence. It's quite important. You know, hearsay evidence and all these evidences, don't make a decision based on inadmissible evidence. You know, in the CCMA context, I'm not talking about an internal hearing. In the CCMA context, that is a reviewable irregularity, making a decision using inadmissible evidence. We only make decisions based on admissible evidence. The evidence stage ends. Your finding is based on what you acquired in the evidence stage. Once the evidence stage has ended, we enter what is called the argument stage, closing arguments. A lot of people they like to use the closing argument stage to introduce new things. Let us say we finish the evidence stage. Now I remember I wanted to say this, but I did not say it. In the closing arguments now, I say, I introduce new things. And now these new things, the employee did not have a chance to contest them. The employee did not have the chance to cross-examine on these new things because the evidence stage has been closed. We can't accept new evidence subsequent to the evidence stage. Now, I am not saying we must be strict chairpersons. You know, sometimes you can close the evidence stage and the employer or the employee says, hey, there's a witness I just remember I was supposed to call and I forgot. And it's a witness which is material to the dispute. You can't say as a chairperson, now the evidence stage is closed. You were supposed to call him that time. No, you can't. It's the same principle where employees have given you bundles and on the employer, and now there's a document which is missing and the parties want to submit it. We can't say, it's too late to give new document, especially if the document which the employee or the employer wants to introduce is material to the dispute. So these steps, although we try and comply with them, they are just guidelines. You can say even when you've closed the closing argument at the evidence stage, but okay, fine, let's reopen it. Because I see there's new evidence being introduced and it seems material. You are allowed to juggle around as long as you give the parties a fair hearing. Closing arguments is not about introducing evidence. It's about recapping what was already submitted in the evidence stage. Why must I believe your version and not believe the other party's version? So it's not a stage where people introduce new things. So we must be careful as chairpersons when parties submit closing arguments, whether in writing or orally, that we don't consider things which were never led in the evidence stage, because we never gave the employee a chance to cross-examine or the employer a chance to cross-examine on those issues. So we look at issues which were already stated in the evidence stage when we are reading the argument stage, and you only focus on those issues. Just imagine you bring in something new to make your decision, which you've got from closing arguments, and this was never put to the employee, or the employee never had a chance to hear this or to cross-examine on this. We don't want to make that mistake. Closing arguments. Why must I believe your version and not the other party's version? Chairpersons, don't rush yourselves. There is nothing in law which says you must listen to closing arguments on the spot. You can adjourn the hearing if you feel as if you've heard enough, and say to the parties they must submit closing arguments in writing. Because remember, closing argument, unlike the evidence stage where cross-examination must take place, there is no longer cross-examination. That's why the legal framework allows closing arguments to be submitted in writing, because the law understands, but you're not introducing new evidence. There is no way the law would have allowed closing arguments to be submitted in writing if the law knew you were introducing fair and new evidence. Because that evidence is no longer going to be tested now. You are just writing a summary. Why must I believe your argument and not the other party's argument? Closing argument. And then once you've heard the closing arguments, obviously you decide on guilt. This is your decision. Remember, if you are chairing a case internal, you are not bound by a previous decision which took place internally. There is this perception chairpersons have that if the previous employee was dismissed for this or was found guilty for doing this, it means I must also find him guilty and dismiss him. Look at this thing in the criminal court context. In the criminal court context, we can have 5 people who commit murder. 5. One of them might receive the life sentence. Another one might receive 10 years. Another one might receive 8 years. Another one might receive 7 years. But all these people committed murder. So we must not say, but I find you, just because so-and-so was guilty, you are also guilty. Just because the same employee who did this was also dismissed, you are also... If that was the case, it means that in the criminal court justice, if you are guilty for murder, the sanction should have been constant. But it's not. Sometimes it's life, sometimes, but the crime is the same. The same principle applies in the legal framework insofar as labor law is concerned. Just because you committed theft and the other one committed, doesn't mean guilt section the same. Just because you did late coming and the other one received a final warning, doesn't mean the next one. The law never said sanctions must be consistent. It said the rules must be applied consistent. Sanctions can be different. What is the purpose of mitigating factors if we're gonna apply sanctions consistent? If the last person was dismissed for theft or for late coming, why are you asking for mitigating factors? It obviously means you're going to dismiss the next person most. So the mere purpose that there's mitigating and aggravating factors, it gives us an idea, but sanctions can be different. You decide on guilt, chairpersons. Use your own mind. Look at the evidence. Were the requirements of misconduct met? Did the employer prove there is a rule, that the employee is aware of the rule, that the employee contravened the rule, that the rule is applied consistently, is valid and reasonable? Were these things proven? Were they proven by admissible evidence? If it's proven, obviously you're going to find the employee guilty. And then we enter the stage of mitigation and aggravation. In the hearing I had Wednesday in Cape Town, I found that employee guilty and I said he must submit mitigating. In his mitigating, he says, I don't agree with the sanction. I think the chairperson was biased. Me, I feel as if the whole hearing was biased. He is still challenging the finding because he does not understand the meaning of the word mitigation. So sometimes employees, they still feel as if once you found them guilty, when you are saying mitigate, they feel as if they can still overturn the finding of guilt. Mitigating factors and aggravating factors are not aimed at overturning the sanction or the finding rather. They are aimed at mitigating, making the sanction lesser, or aggravating, making the sanction harsher. I feel as if the reason that employee did not understand what he was expected to do is because I did not explain to him what mitigating factors are. I just said in my finding, submit mitigating factors within 5 days, full stop. And from that experience, I learned something else. I learned that in the event I direct people to submit mitigating aggravating factors, I will have a follow-up sentence. I would say, mitigating factors, parties, are factors which you must submit to convince me. Why must the sanction be lesser? They are not issues about challenging my decision. Only the CCMA can overturn my decision right now. Or only the internal chairperson in an appeal hearing can overturn my decision. It's only for the purposes of trying to convince me to impose a lighter sanction. Employer, what can you say to convince me to impose a harsher sanction? There is this perception that before we dismiss an employee as chairperson, the employer must lead evidence that the trust relationship has been broken. Guys, just imagine the employer leads evidence and it doesn't make reference to the fact that trust has been broken. He does not make reference to it. He leads evidence the whole day. You don't hear a sentence that says trust has been broken. Are we going to say as chairpersons, but no, trust was not broken? But remember, as chairpersons, we have the right to draw inferences. We have the right to draw inferences. As much as, for example, look at Oscar Pistorius. No one saw Oscar Pistorius shooting his wife. No one. He was found guilty on circumstantial evidence, and an inference was drawn by you, based on the circumstances he shot his wife. Sometimes you look at the circumstances and you also draw your own inference about the trust relationship. Sometimes a broken trust relationship can be accused from the bad conduct of the employee without the employer leading that evidence. I think there's an important case to that effect. I think, if I'm not mistaken, it's Woolworth's case, where Woolworth's case said, but just because the employer doesn't lead evidence talking about the trust doesn't mean as a chairperson you can't draw an inference or accuse that the trust has been broken based on the bad conduct of the employee. So trust is normally what they normally lead on mitigating, and then you make a finding. I mean, and then you tell a sanction. Your sanction case up to you. Remember, the disciplinary code of an organization is a guideline. It does not mean you must always follow the code. You can have, for example, a code which says if someone commits theft, it's a dismissal. And then there was a case I was involved in where, I'm finishing off now for questioning and answers. There was a case I was involved in where an employee walked past another colleague's desk. He stole one chip, about chip LAs. He took one chip and he walked past. And the fellow colleague said, hey, you're stealing my chips, and she reported it. The employer said it was theft. And now, in the hearing, this employee says to me, hey, Mr. Ncume, I have diabetes. I was feeling dizzy because I haven't eaten the whole day. I saw the chips on the table, and I felt as if, wada, I must just take one. I didn't know my colleague would mind. I took the chip and I ate it, and I walked past just to get some sugar in my body. I found him guilty because at the end of the day, it's theft. I look at the code of the company, it says dismissal. But I'm thinking, man, no ways, man. In these circumstances, I am not going to issue a dismissal because it's exceptional circumstances. I gave that employee a final warning, even though the disciplinary code said dismissal. So we must not think that we are there to rubber stamp the disciplinary code of employers. Whatever the code says, we must follow. You decide your own sanction. Look at the mitigating. Look at the aggravating. Ask yourself whether or not is it operationally difficult for the employer to retain the employee or not. Ask yourself whether or not progressive discipline can solve the relationship. Ask yourself, has trust been broken to the extent that it cannot be restored? Because sometimes trust is broken, but it can be restored. So if you feel as if you can implement alternatives to dismissal to restore the relationships, you can do so. Decide on the sanction, communicate your sanction in writing, and then remind the parties of their right to refer the dispute to the CCMA should the employee be unhappy with the finding. I think parties, with all that said, that gives us an idea of how, in general, people attack or comply with these steps. Remember what I said earlier on, there is no book, there is no statute, there is nothing coming from law. These things are derived from common practice and people are trying to follow them accordingly. The law never said there must be a disciplinary hearing at all. All these things are taken from common practice. The only thing the law said, especially in the Code of Good Practice, Schedule 8, it only said the employer must give the employee a chance to state the case in response. And employers, to give employees that chance, they introduce these things of disciplinary hearings. If your domestic worker does something wrong in your house, you're not going to have a disciplinary hearing. You're not going to call a chairperson because the law never said you must have a hearing. All we need to make sure we do is allow the other party a chance to state the case in response. So what I'm trying to highlight is that based on practice, these steps have been adopted, they've been accepted, they became a norm, but there's nothing in law which dictates these steps which must be followed in the hearing. I think with all that said, looking at the time constraints, I think that's where I will end the session. And if you have any questions, you're more than welcome to raise your hands, and then I will allow you to pose the questions. Thank you so much, Advocate Ford.
Thank you so much, Ali, for yet again another informative presentation. I mentioned to one or two of my colleagues that you remind me of a pastor in the way in which you do your presentations, and which means we are all awake and alive after hearing it, filled with energy. If there are questions, I'm going to ask any of the participants to now unmute yourself and activate your camera to the extent that you want to. I'm sure we can facilitate possibly one, if not two questions Failing which, we're going to close the session, and what remains to be done is to thank you for your presentation. So if there are any questions, please feel free to raise your hand. Alternatively, to type your question in the chat box, and I will read it out loud to Mr. Ncume. Well, Ali, I can't see any questions. Perhaps the question I want to put to you, though, is in the example that you mentioned earlier, where the employee had been given an undertaking that he or she would receive a written warning or final written warning, just to be then surprised by the final outcome of a dismissal. How did the employee then respond to that?
Thank you, Advocate Ford. You know, what normally happens, you know, in most workplaces, employers, you know, they like to have what is called pre-inquiries. You know, I'm not talking about a pre-arbitration in the context of the CCMA. I'm talking about meetings which normally happen within the context of certain municipalities. Not all municipalities do that, but it's a meeting whereas the union is called, the employee is called, we sit down, we try and explore measures to resolve the dispute. Now, within that discussion, you know, I think the HR, the labor relations officer, the labor relations department of the municipality was like, okay, fine, we know you committed this. We don't want to incur unnecessary costs and call external chairpersons or brief advocates to come and represent us. Let's come to an agreement. When we go to the hearing, just plead guilty. From my side, I'm going to give you a warning. And this was agreed upon verbally, you know, orally, and everything is fine. Yani, when we get to the hearing, the employee pleads guilty. Now, remember now, as a chairperson, me, I don't know what was discussed. You know, me, no one from labor relations came to me and they said, and when I was looking at the closing arguments, I could see the company or the municipalities arguing for a dismissal, you know, talking about trust, whatever. And now this employee raises this issue now. But hi, labor relations, how can you say trust was broken? But you told me that we agreed, but I must plead guilty in this hearing so that you can give me a warning. Chairperson, and then this thing comes to my attention for the first time. And then me as a chairperson, I just said to that employee, but when you were pleading guilty, I asked you, are you pleading guilty voluntarily? And you said yes. I asked you, were you coerced? And then you said yes. And now I've listened to the entire evidence, which basically means me, I'm going to make a finding based on this evidence. Even worse, in that day, Advocate Board, the labor relations is disputing that agreement. The labor relations is saying, no, we never said that us. There is nothing in writing. There is nothing which was recorded. There are no minutes of that meeting. So I ran with the hearing as it is, you know. So sometimes I think it's advisable to put these scenarios to employees. But hey, I know sometimes you can meet your employer before the hearing and you can have discussions where you plead guilty or what. Did you have any of those discussions? Did anyone say if you plead guilty, you're going to get a particular sanction? So, you know, you test these things so that when you're running the hearing, you are satisfied that the employee's plea was done unilaterally and voluntarily. In that instance, unfortunately, I finalized the case because labor relations were disputing it. I had no proof there was such a discussion, but that employee did raise it. You know, yeah, I think that's what happened.
Thank you, Mr. Ncume. Thank you for your presentation. Thank you for your time. And thank you for your willingness to impart your insights and knowledge with us. It has certainly been yet again a pleasurable experience. And we look forward to having you on this platform in the near future. I see there's a hand by Vusi Mahlangu. Vusi, can you unmute yourself and ask your question? That's going to be the first and only question.
It's not the question, actually, Advocate Ford. Mr. Ncume, thank you so much for the insights and the lot of information. My name is Vusi Mahlangu, as an ER manager at Transnet. I just wanted to find out if are we able to get this presentation, Advocate? Is it possible that one can get a copy of the presentation or the recording? Thank you.
Vusi, are you the same Vusi that went with me to Cape Town some many years ago?
The same Vusi, Advocate Ford. I was thinking after this I'm going to call you, but yeah.
Very, very good to hear of you. Yeah, so
Yes.
the recordings are available on the RSA Bar website.
Yeah, sure.
So the recording will be done, the uploading of the recording will be done and would be made available to you.
Oh, thank you. Thank you so much.
Mr. Ncume, thank you so much for your time again, and we look forward to having you in the near future. And stay as energetic as you are. I'm sure you've inspired all of us, and we look forward to seeing you soon.
Thank you so much, Advocate. Sorry if I disturbed. Thank you so much, Advocate. It's always a pleasure to come to this platform, and thank you to everyone who attended. I trust you derive some benefit out of it, and I'm looking forward to future invites, Advocate. Thank you so much, sir.
Have a good evening, all. All the best.
Thank you.
The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Inovo Santo. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabar.net. The South African Bar Association, transforming the legal profession.